SJC-11532, Trinea Figs v. Boston Housing Authority.
Good morning.
All right, let's proceed. Good
I'll be
morning.
splitting time, Your Honor. I'm splitting 7.5 minutes with co-counsel Angela Marcolina. Each of us can answer any questions on any issue. However, I primarily will be focusing on the marijuana issues, federal preemption, and distribution. She will be handling the gun and the hearsay issues and any other remaining issues. Chief Justice Ireland, Associate Justices, may it please the Court. My name is Michael Lewis, and together with co-counsel Angela Marcolina, we represent the Boston Housing Authority. This case is based on a writ of certiorari case under 249-4. I think it's critical in understanding that the standard for this case is arbitrary and capricious, as set out in Forsyth v. Board of Registration. In addition, LaCave v. Lucander discusses how it's a reasonable person standard.
So in other words, the review of the decision of the BHA is subject to the arbitrary and capricious standard?
Correct.
Okay,
Correct.
not the view of the housing court judge?
Correct. Correct. This case is about an invited guest with a loaded handgun, a dealable amount of marijuana, a digital scale, a box of baggies, and $653.
But may I just ask you, you say a dealable amount of marijuana. We don't know what the weight was, do we?
We do not know what the weight. We know it was in two separate packages. I would say under Commonwealth versus Kiefner, this court said you do not need more than an ounce for distribution. In Kiefner, you had 3 bags of marijuana and you had $98. And this court said that was you could still charge them with distribution. So the weight does not have any effect on the possibility of distribution.
Right, but in Kiefner, there was evidence, apart from the amount of money involved and the amount of drugs, of distribution. And what do you have here?
You have a box of, the box of baggies and a digital scale in a bedroom and a gun.
They were in the bedroom? I see them from the inventory. It doesn't say where they were found.
They were in the bedroom. So what happens is the digital scale is in the 13-year-old son's bedroom. It's on the floor. There's 1 bag of marijuana on the floor. There's 1 bag of marijuana on the nightstand. The box of baggies is on the nightstand. His Massachusetts ID, a Rhode Island medical card, and then the gun is on the porch outside the window.
The defendants, you mean, yeah. I'm sorry, not the defendant. I
the
get it, I get it.
participant's
Not the
brother.
13-year-old.
But
You don't mean
when you say on the, all right, but let's just stick with the bedroom itself right now.
Yes.
So you've got the digital scale and the baggies, right?
At $653.
Right, okay. And the judge, in his decision, I guess, just deals with that with one sentence. There's no evidence in the administrative record that Damon intended to distribute marijuana. Is that right?
That's it, yeah. I don't think he gives any credence to the $653, the baggies, or the digital scale. And the hearing officer talks about those issues and says drugs and drug paraphernalia. And also, it's the fact that it's in 2 baggies. I understand there's a dispute over that. But I think Kiefner shows that you don't need more than an ounce, and also there's these other hallmarks of just drug distribution. I think the gun is considered as well. However, if you remove it, there's still enough.
But I mean, that's a sort of separate, the judge has separate findings about that gun and where its location. I mean, in other words, I think, in fairness, you have to, on the possession with intent, you need to look at, I think, the evidence of the drugs themselves.
That's fine, Your Honor. I would say the judge credits the police officer's training experience to identify the substance as marijuana, and then he doesn't say anything about the training experience to know what the hallmarks of distribution of marijuana are.
If I can turn to the possession issue, I think we all recognize that if there's evidence of possession with intent, we're in a different ballgame. Can it be drug-related criminal activity under the federal law if the federal authorities, as a matter of policy, do not prosecute it?
There's a difference between prosecution and allowance. I think the big thing is, and this court recognized the housing authority's discretion in Garcia, whether the federal authorities actually prosecute for minor marijuana or simple possession offenses doesn't strip the housing authority to terminate for simple possession of marijuana, because there's a direct conflict between.
But remember, under state law, they're forbidden to do so. So they can only do so if they're mandated by federal law. Do you agree with that?
If they're mandated by federal, I think there's a direct conflict, Your Honor. I think the Controlled Substances Act and HUD, the HUD memoranda attached to GBLS amicus brief in 1999 and 2011 state, now granted it's medical marijuana, but they state any medical marijuana statutes which purport to claim marijuana is not illegal are directly preempted by the Controlled Substances Act.
Right, but you also have the head of HUD saying, with regard to medical marijuana, we're not going to terminate anyone's lease with regard to that, or we're going to leave it up to the public housing authorities as to whether they choose to do so.
Correct. So in this case, the lower court is stripping the housing authority of its choice, of its discretion, a discretion which HUD says the local housing authority needs wide discretion.
But going back to what Justice Gans says, if you, putting HUD aside, if it was just possession and under Massachusetts law, you wouldn't be in a criminal environment if it was just possession, right? Because you don't have the weight.
Under Massachusetts law, no.
Okay. I think what he said, and I don't know that you responded, was if the federal government gives you discretion to do it or not, and the Massachusetts law says don't do it, why isn't it an abuse of discretion to exercise the discretion in those circumstances in favor of eviction?
I think the HUD memorandum in 2011 answers that question, and it says, although PHAs and owners are not charged with enforcing federal crimes, requiring them to condone violations of those laws would undermine a PHA or owner operations. I think allowing a federal crime to exist in federally subsidized housing.
That the feds don't even enforce?
Well, I mean, it seems to me that if we were to say that state law forbids a housing authority in a federally run program from applying federal law, that would be problematic, wouldn't you think?
I apologize, Your Honor.
If a state court were to say, we forbid the Boston Housing Authority in their Section 8 program, a federal program, from enforcing federal law with respect to lease terminations, wouldn't that be a preemption problem?
That would absolutely. And it was the problem addressed in Garcia. In the Garcia case where there was an innocent tenant defense under Massachusetts law, Spence v. Gormley, this court recognized that under state law you have an innocent tenant defense, but where you have federal subsidies, you don't have that defense. I would also point out, Your Honors, for example, the Boston Housing Authority has state developments and federal developments. In those state developments, undocumented citizens are allowed to be subsidized, while the federal developments, also run by the Housing Authority, are not allowed to reside there. They have to move to state developments.
So your view is that under federal preemption, if a public housing, that the federal preemption is that under federal law, if the public housing authority has discretion, that a state law which says no, you don't, is preemptive.
Yes, Your Honor. It stands as an obstacle to the Controlled Substances Act.
Counsel, your time is up.
Thank you for your consideration.
Good morning, Chief Justice Ireland and Associate Justices of the Court. My name is Angela Marcolina, and I likewise represent the Boston Housing Authority. This morning, I'll be discussing the issue of the lower court finding that the hearing officer's reliance upon the police obtaining information from a confidential informant lacked the requisite substantial indicia of reliability in an administrative Section 8 hearing. In Duca v. Martins and U.S. v. Cochran, the court recognized the importance of the indicia of reliability and stated that if the police could determine information from a confidential informant was based on firsthand observations or direct knowledge, that was the type of information the police could rely upon to seek a search warrant from the court.
Well, let me ask you this. If what we had was simply a search warrant based on a confidential informant information, and no gun was found, would that confidential informant information be sufficiently reliable to base a lease termination?
No, Your Honor.
Okay.
And I would point out that this court in Costa cautioned against the use of hearsay information that was uncorroborated, that was anonymous, and that was contradicted by other evidence. That is not the type of evidence that you have in this case. The courts acknowledged that you can base Section 8 termination cases on hearsay. The hearsay information that you have in this case is directly corroborated by the police firsthand observations. The police indicate in the search warrant affidavit that this confidential informant for 12 days prior to the search had direct observation of Damon Nunez.
For all of 12 days, each of 12 days?
That's what the search warrant affidavit indicates, Your Honor. It says for 12 days prior, he observed Mr. Nunez. He observed Mr. Nunez in this apartment. He observed that Mr. Nunez kept this black .38 caliber firearm either under the bed in his bedroom or outside the window adjacent to his bedroom on the porch. He gave such specific detail that he knew the layout of the apartment, meaning where the gun was kept in the bedroom.
Not that it was only on the 12 times, but that's what it says.
Yes, the police also note that they themselves observed Mr. Nunez for 8 days prior to the search, coming and going from this residence. They observed that he was staying with his sister, Miss Figgs. The confidential informant had such specific information that he knew the approximate ages of her children. In this case, the police are able to corroborate the information from the confidential informant upon searching the unit. This is not the type of evidence that the court cautioned against in Costa. This court need not reverse or enlarge the findings in Costa to find, in this particular case, that the evidence is not the kind it cautioned against.
Well, I mean, in Costa, I gather it was a police report signed by a police officer based on that police officer's personal observations.
That's correct.
So here we have the personal observations detailed, to some extent corroborated, but anonymous. That doesn't matter?
No, Your Honor, because in Costa, the grievance panel relied upon information in a newspaper article that was not in the police report. There was additional information contained there that was not corroborated by the police report. Here, that's not what you have. What the hearing officer was left with was the firsthand observations of the officers, including that the firearm was kept on the back porch. Now, the lower court in this case makes some inadvertent mistakes with regard to the evidence in the record. For example, with regard to that point, the court says that Mr. Nunez was intimated by the confidential informant to also keep a gun under the bed. That's actually incorrect. It was under the bed or on the back porch, precisely where the police recovered the firearm, which I might point out to the court was loaded with hollow point ammunition and full metal jacket ammunition. This was a loaded firearm. The court also indicates that there was no evidence in this particular record to find that the porch was part of the unit. That was also incorrect. The court can find at Appendix 108 a copy of the lease, which at Provision 2 indicates that all common areas appurtenant to this unit are part of the rented premise.
I thought that wasn't the point. I thought it was because the layout permitted others to have access, because in fact, the door to the outside was an unlocked door, and anybody coming up the stairs needed to access that same back porch in order to go to their own apartments.
Yes, Your Honor.
Wasn't that the point?
The court does make that point. However, the court will note that in the search warrant affidavit, the police indicate that this was a forced entry. Both back and front doors were breached, so they appear to be locked at the time.
Yeah, but
To the apartment.
But people, other people, the point is, as Justice Duffy just said, other people have access to that porch.
Other people may have had access to that porch, and the hearing officer and the lower court concede, Your Honor, that in this particular case, the explanation given by Ms. Figgs was that that access was essentially that sometimes that outside door was locked that led to a common stairwell, and that you might be able to pull yourself up from the lower floor porch. I would argue, Your Honor, that the hearing officer didn't find that a reasonable explanation, and in fact, the lower court concedes in its decision that there were two possible plausible inferences that could have been drawn from the evidence. The first being that Damon or a member of Ms. Figgs placed the gun, Ms. Figgs' family placed the gun on the porch, or that some other person did. Given that the hearing officer's inference was that a member of Ms. Figg's family, or specifically Damon, had placed the gun there, given that this is a preponderance of the evidence standard, I would argue that the hearing officer's inference was likewise a reasonable one. And unfortunately, due to the standard of review that the lower court was examining this case with, the lower court did not have the ability to revise findings of fact in this case.
Can I switch topics for a minute? Assume that one or more of the points that you are making is correct. Can you explain or talk about the adequacy of the hearing officer's consideration of individual circumstances for Ms. Figgs herself?
Yes, Your Honor. The hearing officer in this particular case did consider all of her mitigating circumstances. He considered that she had 3 young children residing in the unit. He also considered that the family members themselves were not directly involved. But what he does arrive at in his conclusion is that because Mr. Nunez was an invited guest, and because Ms. Figgs had violated the lease, and the violation was quite serious, given the totality of—
Violated in what respect?
Well, Provision 10A of the lease, Your Honor, prohibits a household member or guest under the head of household's control from engaging in any illegal or criminal activity in the rented premise. And given the totality of the circumstances in this case, the hearing officer draws upon the drugs, the drug paraphernalia, the gun, which was loaded. He indicated that the seriousness of the violation outweighed the mitigating circumstances in this particular instance.
I take it the drugs were also in plain view in the room.
They were, Your Honor.
Counsel, your time is up.
Thank you.
Thank you.
May it please the Court, Jeremy Robin for the appellee Trinea Figgs. It's a privilege to be here today. The first point I'd like to make is that Judge Winnick got it right at the trial level. Gave us a 12-page decision which was thorough and well-reasoned, entirely devoid of the requisite error of law or abuse of discretion which would be necessary to upset his
Did
decision.
you say he applied the arbitrary and capricious standard? You would say that the ruling of the Housing Authority was arbitrary and capricious?
He found error of law. That's what his
Error of law in what respects?
Well, that the 2 bases for terminating the voucher, drug-related criminal activity or serious violation of her lease, were not met. Because here you essentially have a possessed marijuana case.
But let's just focus on that. I know that the judge says there was no evidence in the administrative record that Damon intended to distribute marijuana to others. You do have baggies, you've got a scale. That's money?
Right,
That's
there's
no
money
evidence?
and there's an older child, and there was an explanation that that was his money. You have a firearm which is in an adjacent common space.
No, I'm not counting the firearm. I'm just looking at what's in that bedroom. Baggies on a nightstand, marijuana on a nightstand, marijuana in a bag on the floor, and a digital scale.
Okay, well,
And money.
Sure, the marijuana in the baggies, possession. Scale could be used for other things.
A box of baggies possession?
Well, I'm not an expert on drug possession or dealing, but it seems to me it could be. And again, Judge Winnick was in the best position to determine,
Judge Winnick was in the best position?
well, to determine the propriety, if you will, of the hearing officer, the Housing Authority's hearing officer report. And,
Why is he in a better position than we are? I mean, it was the Housing Authority that took evidence and drew conclusions and made findings.
up to this point, And if in reading his report, he was ever deferential to the Housing Authority in every way. And again, he found that the 2 bases for terminating drug-related criminal activity and serious lease violation were not met here. And it's interesting to note that the BHA on its own had previously discredited the other reasons for terminating, namely the illegal occupancy by the brother and the failure to decertify contentions.
Do you think we could rule that the Boston Housing Authority in federally funded housing cannot enforce or cannot use a violation of federal criminal law as a lease violation? Do you think that would be something that we could do?
I think you can, but I think that we don't even need to get there because
Okay.
drug-related criminal activity is defined under the statute, 42 U.S.C., quote, "the illegal manufacture, sale, distribution, use or possession with intent to manufacture, sell, distribute, or use a controlled substance. Simple possession not covered there. Serious lease violations, HUD at Federal Reg 56909, doesn't cover all wrongful conduct. Threat includes threatening the safety of other residents, failing to pay a significant rental arrearage, and causing extensive damage. Again, Judge Winnick found this was a case of possession, undisclosed amount, and I don't even think we would need to necessarily get to the preemption issue, because the termination of this voucher does not fall into either of those categories.
So you're saying that possession of narcotics is not a lease violation?
Heroin?
It's not a serious lease violation as defined in the statute. As I read that language,
Well, you have, I mean, you're referring to the definition of drug-related criminal activity, I assume?
Right.
I mean, the problem I see is that it's possession with intent to distribute or use.
right,
And why would one possess it if not to distribute it or to use it? What's the alternative?
that's a good point. If the officer came into the apartment and saw use, then clearly we'd have a different ballgame here. There's no evidence of that, so
But it's possession with intent to use. I mean, why else would you, as Justice Gant says, why else would you possess it?
well, I think if, we can speculate, obviously, any number of options, but, the strict construction of that definition hasn't been met here in these allegations, in my view. And terminating a voucher is a big thing, and I think it has to be very carefully applied, and it can't be subject to.
That's not the judge's reasoning, though, correct? I mean, the judge's reasoning seemed to, at least as I read it, I don't, he seemed to put to one side possession with intent, but with respect to possession, was that it might have been a serious lease violation before the referendum passed, and that with Section 32L, Massachusetts law prohibited use of that. Just Massachusetts law would say that's not a crime, and therefore that would not be criminal drug-related activity under Massachusetts law. I thought that was the basis of his decision, not that it was not possession. I mean, that it, yeah.
Well, that may have been the basis of his decision. I'm going at this argument at a slightly different angle, but I can certainly address the preemption point, because the first thing in preemption is we have to look at the federal statute, and that's something, with due respect, that the Housing Authority and its amicus briefs have not done. The CSA specifically authorizes states to regulate drug-related criminal activity, and that's exactly what Massachusetts is doing here, and other states may well have done that as well. So states are not precluded from regulating drug-related criminal activity. There's no positive conflict, and the Housing Authority would have us believe that any difference between the two laws means that preemption must apply, and that's
Well,
that's
no,
not
I think the
case.
argument is that that the Housing Authority has discretion, and to say that it doesn't have discretion falls into the preemption problem. And in this case, it exercised its discretion.
Okay. Were the state statute a use statute, were it to say, were it to permit marijuana use, I think we as well would have a different ballgame. That's not the case here. Those aren't the facts. So there is no positive conflict. The CSA specifically authorizes regulation of drug-related criminal activity. And even if we were to get to the preemption argument, I think that one fails as well. I'd like to comment a bit on the Costa case and the fact that Judge Winnick brought that in. He properly questioned the police officer's blanket reliance on the uncorroborated anonymous evidence.
Well, it was hardly blanket reliance. I mean, this is a known confidential informant. The affidavit sets out 3 other instances in which the informant has given valuable and accurate information with respect to drug activities and criminal activities. So it's not just some phone call. It's someone known to the police who has got verified performance standards. Now, that might be not enough, but that combined with the gun being found where the informant said it would likely be found is pretty powerful, credible stuff.
I would absolutely agree that were the gun found in the apartment, we would have, again, a different ballgame, but we can't, pick and choose the facts. Fact is that Judge Winnick properly discredited, or at least questioned, whether the gun belonged to the brother. It was found in an area where others could access, And
But this is an arbitrary and capricious standard, so he's sort of reweighing the evidence and saying, well, I don't think that's as credible as the housing officer thought.
respectfully, I disagree. He gave us 12 pages and put a lot of thought and time into this. And
So did the housing authority.
I don't know if theirs was 12 pages and researched, but the fact of it is.
Isn't your stronger point that the fact that possession of marijuana has been decriminalized here ought to be a factor?
Right.
Not that it isn't a lease violation, but ought to be a factor in whether termination is appropriate.
I would agree with that.
Okay.
Whether it falls into that category of serious lease violation. But even still, I'm just vetting the fact that even without that, I don't think it falls into that category as I understand and read the definition.
So if you prevail, what's the rule going forward? What do we tell the public? If you live in public housing and you possess less than an ounce of marijuana, you don't have to worry?
I don't think it would be that concrete. I think that you know, it's a privilege to have a voucher, but I think to take it away from someone, particularly in this case, Ms. Figs, where there's some mitigating circumstances, which I haven't really even gone into, but I don't think that in and of itself should be a basis. I mean, our legislature has said that possessing marijuana is not a crime. So are they saying that it's okay to possess marijuana? You know, it's not a crime. It's just, you know, civil.
Well, it's
civil-
illegal, it's just not a criminal offense.
But with due respect, think that, I mean, I don't know, that's your job to determine what the rule going forward, but I think that it should be, it takes a lot to terminate a voucher. And it takes certain clear things, more than mere possession of marijuana. Not to condone or excuse marijuana, but to take away someone's voucher is very different than evicting someone.
Would you agree possession with intent is a different category?
Absolutely, absolutely. As would be the firearm if that were woven in here. But again, those were discredited.
Can you turn to the individual circumstances?
I'm sorry, can I?
Can you turn to the individual circumstances?
Sure, and I think in reading Judge Winnick's decision, he did not feel he needed to get there.
Right.
But this is a woman who had played by the rules, and it was her brother that allegedly possessed the marijuana, unbeknownst to her, who was watching her kids, and she had been in good standing, she was working, 3 young children, I believe honor roll students, as I remember. So there were very strong mitigating circumstances, which, if we needed to get to, would be very applicable here, I believe.
Well, does it, there's sort of a two-edged sword here with regard, what's for a metaphor with the gun. A loaded gun left in a, I guess the question is whether or not it's hers, but I mean, to the extent that it's a problem to have a loaded gun in an area which has access to various units. I mean, that's a problem for any housing authority or for any landlord. How do we deal with that? Do we say that the evidence is inadequate as a matter of law, that it's arbitrary and capricious for the hearing officer to have found that it was in the possession of her brother?
I think so, yes. I think so. Because there's no condoning of a loaded firearm. Obviously, it's an extremely dangerous situation, and that's the position that the housing authority takes, properly so.
But you agree that to reach that finding, we would have to say that we give no weight to the CI information?
I think we have to, because what if it were someone else's firearm? Then we're going to punish Ms. Figs because someone who's anonymous, who's uncorroborated, is saying, yeah, that's his. Maybe it's someone who has a vendetta with him. I'm speculating, of course.
12
but it could be any
days
number
of
reasons.
going, I mean, saying anyway that he's observed him personally in there 12 days in the apartment?
Well, you know, those were factors to be considered, but clearly there's a lot at stake here, terminating someone's voucher. And I think that needs to be the signature point. There's a lot at stake, and the bases have to be significant.
With regard to other administrative agency decisions, which matter a great deal, what is the law with regard to the admissibility of CI information? Do you know?
I'm not sure. I don't have anything further if you have any.
All right, counsel.
Thank you very much, though.
much.